Christa, another thing that we were commenting about while this testimony was happening was the lack of a sidebar. There was arguments between the attorneys regarding objections and the basis of those objections in court, with the jury present, in earshot of the jury, and no sidebar or the jury being excused. What do you think about that? And again, how could that be problematic at trial?
I think that, we were joking that it was the wild, wild west out there. This is very rare. Most judges hold attorneys to say the word objection and what the grounds for the objection is. So it's objection hearsay, objection relevance, objection calls for speculation. Once you start getting into the arguments in front of the jury, that is revealing information to the jury that may not ultimately be admissible, or you're telling the jury how they should think about and receive information. And that's just completely inappropriate. What should happen is all of those arguments that you're hearing take place while counsel is seated at counsel table and the lectern, is to have that done quietly at sidebar. I'm noticing that even at sidebar, and we're looking at a picture of that here, that it doesn't appear that there is any steps being taken to make sure that the jury can't hear information that's being discussed at the court's bench. Normally, that would be done with a white noise machine, or even taking it completely outside, or whispering at literally at the sidebar of the around the corner of the bench, so the jury can't hear you. It just tells the jury what to think and feel about evidence that it may or may not ultimately be able to hear, and it's just not typical.